National Manufacturing Innovation Survey. What may be the possible questions from this one? I can give you the question paper before this article explanation, but you may get confused because of various questions set by each article, set from each article only. Let me come to this one. Which of the following statements about National Manufacturing Innovation Survey 2021-22 survey is correct? This is a basic model of question that may be possible, like a statement-based question without elimination. Of statement 1 and 2, like assertion and reasoning. From this article only, like National Manufacturing Innovation Survey 2021 and 22 study evaluated the innovation process outcomes and barriers and manufacturing firms. You haven't known anything about it, isn't it? You haven't read it, but still you should be able to draw some inference to make this question correct. You should be able to do something, right? Because 75 to 80% of the questions are not known to most of the serious aspirants in the original exam. Ultimately, it is not possible for anybody. It is the maximum possible number of questions that confidently an aspirant can attempt are not more than 25 MCQs for last 3 to 4 years of the paper if you observe. So, let's come to this conclusion. How can you answer this question? This is National Manufacturing Innovation Survey. Instead of typing everything, just I have given shortcut. Study evaluated the, by default, National Manufacturing Innovation Survey it is showing. National Manufacturing Innovation Survey. So, this innovation, the term itself is providing an opportunity to make this assertion as right. There may be possibility that assertion may be right. And next, reasoning is, the study is follow-up of DST's first National Innovation Survey held in 2011. This is a little difficult one, whether it is a follow-up or not. Here you need some value addition and confidence. Suppose you are not able to remember after reading all the current affairs for last 1 year PTs, okay? Still, you have an option. You have an option that you will not be having fear factor because of the completion of all the topics that were covered last 1 year. So, you will reduce your fear factor after revising and reading all the components that were discussed. You may eliminate some kind of fear factor here. And next thing is about which of the following statements about National Manufacturing Innovation Survey 2021 survey is correct. This is providing you an opportunity to eliminate at least 1 or 2 statements. But still, there is no possibility for you nowadays in the UPSC examination. There is no elimination, as you have known. So, what is the possible, probable combination of options that may be possible to be correct, right? Suppose there are permutations and combinations. How many of the statements can be possible to be correct? How many of the statements cannot be possible to be correct? The possibilities, what is probability? Number of possibilities out of impossibilities. Okay, if there is 1% impossibility, you should not opt that one. If there is at least 1% impossibility, you should never opt that statement. Okay, so that is the basic fundamental idea. Let's come to this application. You may not, at least you cannot eliminate, you may not be knowing each and every statement given in here. You may not be knowing each and every statement given in the MCQ. But you should be able to draw 50% of the statement whether correct or wrong. That may fetch you to draw at least 4 to 5 questions out of 10 questions. And 2 may be wrong and 3 may be right. This is actual scenario of most of the serious aspirants. Therefore, they may be able to be in the edge between 85 to 90. So, coming to this basic logical technique, applying this basic logical technique, I think everybody is following me, right? Okay. National Manufacturing Innovation Survey study evaluated the innovation processes, outcomes and barriers in manufacturing firms. Is there any dispute with respect to this statement? It appears to be possible one, right? Is there any chance of impossibility in the given statement here? You don't know anything, because ultimately you might have read hundreds of books. It is not possible for you to get at least 10 MCQs out of those 100 books. This is the fact. So, what is actually the examiner judging and discussing here? So, based on your PYQ's ability, you may be able to attempt at least 10 questions. Based on your foundation and basics from NCRTs, you will be able to attempt 10 to 15 questions. So, 25 questions you will be attempting confidently. And remaining 75 questions that you need to apply your spontaneity, originality in the examination hall. So remaining 75 questions, checking and determining, actually validating your capability, your brain's equanimity ability, your stability, right? So how stable, how confident, how peaceful and composed you are while attempting the question and assuming whether the statement is correct or wrong. Let me come to the statement. The probability of making the statement is 100%. Appears to be 100%, isn't it? Yes, the first statement is not giving you any kind of dispute whether to make it correct or not. And second statement, coming to the second statement. The National Manufacturing Innovation Survey focus solely, I am repeating, National Manufacturing Innovation Survey focus solely on the innovation ecosystem affecting the innovation outcomes. Is there any chance of 0.001% of impossibility from this statement? Yes. If I have given you one trick that if there is at least 0.0001% of impossibility in the given statement, you can, yes, maximum you can make it incorrect. At most of the cases, the probability is 90% to make it incorrect. Okay, to assume it as incorrect, the probability. So, National Manufacturing Innovation Survey focus solely on the innovation ecosystem affecting the innovation outcomes. So, eliminating the second statement is probable one, the probability. Out of the available choices, 100% it may be eliminated and it may be chosen at least 99%. See, the probability to choose may not be 100%, but probability to eliminate may be 100%. Are you getting what I am saying? Probability to eliminate a statement is absolutely 100%, but probability to choose a statement whether correct or wrong is only not more than 99%. With your assumption, you cannot make you cannot assume that the statement will be 100% right. Only based on your assumption, you cannot conclude that this statement will be 100% right. Only based on your assumption. But based on your assumptions and inferences and corollaries that are asked in CSAT paper actually, these terms, but these should be applied, the skills should be applied in GS1 as well for unknown questions. So based on your inference and assumption and corollary, the option which is going to be wrong is mostly correct, okay, from your side. So if you feel that this option may not work out in most of the cases, at least in one case, in one aspect, this option may not be correct, therefore you can comfortably eliminate that one. This is an option here. So, National Manufacturing Innovation Survey focus solely on the innovation ecosystem affecting innovation outcomes is having a chance of making it incorrect, right? This may be incorrect statement. So, you can eliminate that one. So, Karnataka had the highest share of innovative firms at 46 point some change. So, in the original exams, they will not torture you that much. Okay. In figures, in original exams, if you observe 41 years of UPSC question paper, for example, 2016 paper, I am referring 2016 question paper. In 2016 paper, what did they do? $1,000 billion per annum is the mandatory amount to be paid by developed countries to the developing countries under Kyoto Protocol. Per annum, the number was mentioned as 1,000. Instead of 100, they have mentioned 100. So very simple. Then that 10 is making you that statement is correct or incorrect. Simple. Actually, it is $100 billion. So likewise, 99.9%, the figures and facts, exact figures, are not given correct in UPSC 40 years of papers. In most of the cases, if you observe the trend, I have referred one question in 2016. Similar questions, if you observe the trends, academic trends, increased growth rate and imports, exports, something else. When they ask you the exact figure, there may be a possibility of making it incorrect. So they will not torture you like me here, which I am giving you the statement, okay, in the original exam. So making it incorrect in the original exam, there may be a possibility of making it incorrect in most of the cases by observing the trends of UPSC. But ultimately you need to take risk. You cannot attempt only 25 questions in the original exam. you should be able to attempt at least 80 to 85% of the questions. At least you must be able to attempt 80 questions with complete presence of mind and composed mindset in the original exam. So the possibility of making it incorrect. First statement is correct, second, third may be incorrect. Likewise, if you assume. Next, the National Manufacturing Innovation Survey 21-22 is the first innovation survey conducted by Department of Science and Technology. National Manufacturing Innovation Survey, Innovation something, DST, Department of Science and Technology, some relation may be there. There may be some relation. Okay. So out of these statements, two are from your part, two are confirmed. So coming to this actual article, instead of directly discussing the article, I am showing the MCQs. So you should be able to develop your skills, whether the statement is correct or not. You have to solve yourself. After that, you have to read the article. This is a basic reverse engineering technique. This will help you to align your mind while reading the article according to the lens of the UPSC. You will be seeing each and every article through the lens of the UPSC. Okay. For that, you need to see the MCQ first. Therefore, your mind will be directed to see the article through the lens. Coming to this article, what is this article talking? This National Manufacturing Innovation Survey, a joint study by the Department of Science and Technology and United Nations Industrial Development Organization. So you need to know two things again. What is DST? What is UNIDO? The Department of Science and Technology, it is under Ministry, one of the departments. That is fine, no problem. UNIDO is United Nations Industrial Development Organization, which is mandated to support developing countries for their industrial growth. Basic function. And it's headquartered in Vienna, capital of Austria in Europe. And there are permanent countries, 60 countries. And also, by this time, there are around 170 countries members of this UNIDO, United Nations Industrial Development Organization. Likewise, when you see something related to newspaper, some organization, international organization, you need to immediately learn there. Itself you have to finish. There itself you must complete the international organization. Now you have known about international organization, that is UNIDO. Its headquarters is in Vienna. Our permanent presence in our 60 countries. And next, UNIDO was established in 1966 by the UN General Assembly. UN General Assembly established this UNIDO, United Nations International Industrial Development Organization, to accelerate for industrial growth in which countries? Developed countries. So as of now, around 170 members are there in UNIDO. This is about international organization. So this is actually being part of National Manufacturing Innovation Survey, DST, in collaboration with DST. So these are the only things that you need to learn for preliminary examination from this article. Remaining things that the article, suppose Karnataka is the topmost one, and next followed by Telangana and Tamil Nadu. And least performing states here are always Odisha, Bihar, Jharkhand. Okay, this is the only thing that you need to learn from this article. Remaining elements are not required. Likewise, you need to go through other article as well. The article is talking about divorce can be granted on grounds of irretrievable or irretrievable breakdown. That is Supreme Court. Supreme Court is talking about issue of divorce. Okay. Here from this article, you need to learn about Article 142. What is meant by Article 140? It was used several times. Even in the case of Ayodhya also, this Article 142 was used to do complete justice. Supreme Court may go beyond certain constitutional norms to do complete justice. Not only the procedure established, but also due process and also certain natural principles to do justice. Okay, universal principles of natural justice. It may consider various other aspects also to do complete justice under Article 142. This is a fundamental theme, understanding about Article 142 from this one. By using this Article 142, if people in a relationship are extremely under suffering, they can comfortably break down. Then you need to wait for a local verdict, the local judgment which may come after 1.5 years. Okay, if their relationship is extremely strainful and it may lead to some kind of cruelty, okay, therefore they may immediately break their relationship. That is known to be irretrievable breakdown of marital relationship. So by doing this complete gestation, however, it should be very cautious in nature. That was also reiterated by Supreme Court. Very simple. So what may be the possible questions from this article? What may be the possible number of permutations and combinations from this article? Assertion reasoning, statement 1, statement 2, okay, regarding article 142, or regarding the recent judgment. Okay, let's come to one type of a question from this article. What extraordinary power does the Supreme Court have under article 142 of the Constitution? As I have mixed both these concepts, that is article 142 and also the judgment related to it. Here, what extraordinary power does the Supreme Court have under article 142 with respect to highlighting the recent judgment, that is irretrievable breakdown of marriage. Here there are 4 statements which are lengthy in nature. You need to focus very exact with conceptual clarity. You must have some conceptual understanding. Like example, last year they have asked a question related to prisons. Okay, under which list, that is also fine. But after deriving some inference from statement 1, you can make statement 2 as substantiating 1 to the statement 1, and both are true, and one is substantiating others. Okay, so likewise you need to have some conceptual understanding with respect to fundamentals and basics of the Constitution, that is article 142, and that is federalism and concepts related to it. Okay, next coming to this one. See, the power to grant divorce by natural consent without following procedural requirements. Whether option 1, that is statement 1, option 1, here option 1 only 4 options are given directly. The power to grant divorce by mutual consent without following procedural requirements. Without following procedural requirement. Is it making any sense? Please read it thoroughly. Without following any procedural requirements, the power to grant divorce by mutual consent. Let me read other statement as well, because you cannot conclude by one reading only. Okay, by one statement. So the power to, this is also one of the important techniques that you need to remember. Irrespective of vague or arbitrary statement given in the first option itself, irrespective of very vague arbitrary option given in the first instance, you need to read entire question. You should never jump into the conclusion immediately. Are you getting my point? So the first statement may be absolutely absurd. You cannot conclude, you cannot say that the statement may be possible to be correct. Still, you have to read entire question. The question here, you need to read, the first statement appears to be very absurd, because without following any procedural requirements, with the mutual consent, they can go for divorce. That is the option here. Still, you cannot conclude that this option is incorrect. Maybe, possibility, out of, and third trick that I am going to tell you is, you need to choose best relevant option among the given relevant options, especially in the CSAT comprehension part. You must choose the most relevant option among given similar relevant options there. That is also very important. Okay, next coming to this one. The power to grant divorce by mutual consent without following procedural requirements. The first statement, whether it is correct or not, but your mind is saying that there may be a logical sense this question, this option may be incorrect. Okay. Next, the power to quash pending criminal or legal proceedings related to domestic violence or dowry. The power to quash pending criminal or legal proceedings related to domestic violence or dowry, because it was also given in the article. Therefore, that is why I have chosen this statement. The article, because there is huge pendency of cases in the Supreme Court and High Court, especially with respect to criminal cases as well, not only civil cases, but because of conversion of these civil cases into criminal cases. Every dowry act is becoming criminal again. So, because 498 is coming into picture. So, when many cases are under pendency, therefore Supreme Court is to reduce such a pendency of cases, which is taking 1.5 years, 2 years time to mutual consent, divorce for the cases related to divorce with mutual consent. Therefore, Supreme Court is using this article 142 to do complete justice. What is this article 142? It can go beyond the constitutional norms to do complete justice to both the parties Okay, by using due process of law and also basic fundamental principles of natural justice, right? So coming to this one, this is also given in the article, but you cannot conclude that this is the right option. And next, the power to establish and constitute the Supreme Court. The power to establish and constitute the Supreme Court. It is very vague compared to first one. The power to review any of its judgments or orders. The power to review any of its judgment or orders. See, to do complete justice, it may consider anything. It can also review under various other judgments also, not only under Article 142. It can use Article 139 Court of Records. Okay. So it is not a complete relevant option. Article 142 can use anything. Okay. Even judge's conscience can also come into picture while using that Article 142 to do complete justice. A judge may feel that he is not guilty. He may give some chance, or he may do some justice, and something is not proven yet. Okay. So this may be possible, but this is not relevant with respect to irretrievable breakdown of marriage in the recent judgment. What is the question here? Article 142 may be possible with respect to fourth option, but with respect to, as highlighted in a recent judgment on irretrievable breakdown of marriage, with respect to this recent judgment, the fourth option is not relevant, isn't it? Only with respect to Article 142, Supreme Court can go for various other options. It can review its own judgment to do complete justice, naturally, right? But with respect to this particular highlighted one, you cannot conclude that fourth option is correct. You cannot say the third option is very vague. And second option, quash pending criminal legal proceedings. For that purpose, it hasn't taken, because under Article 142, what is the highest priority of the Supreme Court while using Article 142? To do justice to both the parties, to do holistically to every party, all the stakeholders. Okay, it is not for the purpose of reducing pendency of the cases. That is inevitable or consequential effect out of this decision. That is not the primary motive of the Supreme Court while using this Article 142 as highlighted in the recent judgment, that is irretrievable breakdown of marriage. With respect to that judgment, Supreme Court's highest priority is not about reducing pendency of cases. Its highest priority. Okay. The power to grant divorce by mutual consent without following procedural requirements. Now you have understood. Choosing most relevant option among given relevant ones. In the first instance, please tell me, everybody, you might have understood this. In the first instance, while reading option A, what was your opinion? Without following basic procedural norms as procedure established by law. Procedural norms means procedure established by law. Without following these procedures established by law, you can take divorce with mutual consent. This was the first statement. Without following procedure that was established by law. Under Article 142, that was Supreme Court statement, means inference. But in the first instance, while reading the option A, what is your feeling? This is not a possible one, because how can you take divorce directly without following basic procedures established? There are many laws, Hindu Marriage Act, under Civil Procedure Act, something else there. So without following procedure, but when you come to this option B, C, D, what will be the final conclusion? Option A should be the right one. Okay. Remaining options may be relevant to Article 142, but not with respect to the recent judgment. Are you getting what I am saying? So this is an extra edge for an aspirant who is very composed in the examination hall, who is very smart and comfortable in understanding questions and solving many questions like this, who understood UPSC by reading various previous year questions and analyzing PYQs, how they are twisting these statements, who is very composed and calm, comfortable in the examination hall. They can quickly grasp what is relevant option, what is the probable option that is going to be correct 100%, that is not going to be correct 100%. Okay, by analyzing holistically in 360 degrees each and every option, you are concluding the relatively less arbitrary statement is the correct one. ultimately option A appears to be arbitrary one in the initial stage, but relatively it is less arbitrary compared to one or more relevant compared to other relevant options. Are you getting what I'm saying? Right. So likewise, without knowing anything regarding the irretrievable something marriage, divorce, ఏవో కొట్టుకుంటున్నారు చచ్చిపోతున్నారు అని మనకు తెలియదు, irrespective of that అయినా కూడా నువ్వు కరెక్ట్ చేయగలుగుతున్నావు, అవునా కదా? సో ఇప్పుడు మళ్ళీ ఇక్కడ వెళ్దాం. సుప్రీం కోర్ట్స్ ఎక్స్ట్రాడినరీ డిస్క్రిషన్ అండర్ ఆర్టికల్ 142 of the constitution, article 140 of the constitution can be used to grant divorce by mutual consent, sparing couples misery of waiting for local courts to declare annulment final. So suppose, just use my sense, there instead of giving the question and explanation, I have taken the direct statements, and here itself I am discussing whether this statement is correct or wrong, because there is no option for you to eliminate here. I have given 7 statements. How many of the above statements are correct here? I am asking. So why should I frame a complete question here? I have to give 7 statements. You have to tell me which is right statement or wrong statement here itself. Okay. So the Supreme Court's extraordinary discretion under Article 142 of the Constitution, which can be used to grant divorce by mutual consent, sparing couples the misery of waiting for local courts to declare annulment, is final one. Whether this statement is correct or wrong, because already we have discussed, so you can comfortably tell this is the correct statement. Okay. Next, coming to the second statement, I will not display whether it is correct or wrong here. After your observation only, I will display. The same extraordinary power can be used by the court to quash pending criminal or legal proceedings related to domestic violence or dowry against either party. The same extraordinary power. What is that same extraordinary power? With respect to Article 142, extraordinary power can be used by the court to quash pending criminal or legal proceedings related to domestic violence or dowry against either party. Can be. And fourth trick that I am going to tell you here is, if any extraordinary thing come into picture and any possibility given in the option, suppose extraordinary itself is beyond certain threshold, and possibility term, possibility means maybe, can, directly they may ask you possible. Are you getting the keywords in the statement? Maybe, can, possible. ఈ స్టేట్మెంట్స్ లో మీకు ఇచ్చిన స్టేట్మెంట్స్ లో కెన్, మేబీ, పాసిబుల్ అనేవి అడిగాడు. పైగా అక్కడ అడుగుతుంది దేని గురించి? సంథింగ్ విచ్ ఈస్ బియాండ్ ఎక్స్ట్రాడినరీ సమ్ ఎలిమెంట్స్. సపోజ్ ఫ్యూచర్లో స్పేస్ టెక్నాలజీ గురించి ఏదో జరగబోతుంది, ఆర్టిఫిషియల్ ఇంటెలిజెన్స్ మీద ఏదో జరగబోతుంది, ఇంటర్నెట్ ఆఫ్ థింగ్స్ గురించి ఏదో జరుగుతుంది, ఇంకా రీసెర్చ్లో ఉన్నాము. బియాండ్ యువర్ అబ్జర్వేషన్ అండ్ రీసెర్చ్, డార్క్ మ్యాటర్ గురించి ఏదో అడిగాడు. బియాండ్ యువర్ అబ్జర్వేషన్ అండ్ రీసెర్చ్, కెన్, పాసిబిలిటీ, మేబీ అనే వచ్చాయనుకోండి, దేర్ మే బీ ఏ పాసిబిలిటీ ఆఫ్ చూసింగ్ దట్ స్టేట్మెంట్ ఈస్ కరెక్ట్. 99% మనకు వచ్చిన ట్రెండ్లో, యూపీఎస్సీ ట్రెండ్, ఇఫ్ యూ అబ్జర్వ్ లాస్ట్ 41 years ఆఫ్ యూపీఎస్సీ ట్రెండ్, దేర్ మే బీ ఏ పాసిబిలిటీ ఆఫ్ చూసింగ్ దట్ స్టేట్మెంట్ ఈస్ కరెక్ట్. ఇజంట్ ఇట్? సి, జస్ట్ అజ్యూమ్ ఇంటర్నెట్ ఆఫ్ థింగ్స్ వల్ల మీకు ఏమేమి ప్రయోజనాలు ఉంటాయి? కెన్ యూ డిఫైన్ దీస్ ఆర్ ద ఓన్లీ బెనిఫిట్స్? కెన్ యూ కన్ఫైన్ దీస్ ఆర్ ద ఓన్లీ బెనిఫిట్స్? వాట్ ఆర్ ద నెంబర్ ఆఫ్ పాసిబిలిటీస్? So the permutation or combination, if you draw permutation combination, the probability of available choices, out of available choices, there may be 100 options. So you have to choose that one. So Article 142, which is an extraordinary power given to the Supreme Court to do complete justice, and by using this article, if it feels that there is huge pendency of cases across the country, to reduce this pendency of cases, can I use this extraordinary power? Yes. Can I? I am asking. Can I? Yes. I must use ante wrong. I must use ante wrong. I should ante wrong. I can ante right. Terms అర్థం అవుతున్నాయి కదా? ఇక్కడ టెక్నిక్స్ తోటి మనం కొట్టాలి. Right? The same extraordinary power can be used by the court to quash pending criminal or legal proceedings related to domestic violence or dowry against either party. Are you getting? Yes. So అక్కడ కరెక్ట్ అని ఇచ్చేసింది. రైట్. Next, coming to entire law of divorce is built predominantly on assigning fault to one partner or the other. This is common sense. Next, fifth technique is about common sense. So basic గా డివోర్స్కి వెళ్తున్నారంటే ఏంటి, బేసిక్ డివోర్స్కి వెళ్తున్నారంటే అదొకే, బట్ ఇక్కడ ఆల్రెడీ దిస్ ఈస్ ద స్టేట్మెంట్ గివెన్ బై ద సుప్రీం కోర్ట్ ఇన్ ఇట్స్ రీసెంట్ జడ్జిమెంట్ ఓన్లీ. ఐఎమ్ టేకింగ్ దోస్ స్టేట్మెంట్స్, బట్ by having some simple common sense, people who are in dispute, they may make allegations to each other, especially wife and husband, without taking divorce also they make allegations to each other, right? General tendency. So it is very common. So the entire law of divorce is built predominantly on assigning fault to one partner or the other. Okay, this is statement given. Next, irretrievable breakdown of marriage is a recognized ground. Irretrievable breakdown of marriage is a recognized ground for divorce under the Hindu Marriage Act. Yes, under the Hindu Marriage Act only that statement was used. Why should I use breakup ane vaadachchu kada nenu? Why should I unnecessarily noru dirakapaina irretrievable breakdown of marriage? Why should I use? Because it's legal term. This is a possible question, so the possible statement will be from this one only. So irretrievable breakdown of marriage is a recognized ground for divorce under Hindu Marriage Act. Okay, despite recent judgment, irretrievable breakdown of marriage is not at a ground for divorce under the Hindu Marriage Act. This term was mentioned in Hindu Marriage Act, but breakdown of marriage is not a ground for divorce. Okay, this statement, this legal term is part of Hindu Marriage Act. బట్ హిందూ మ్యారేజ్ యాక్ట్ నేను పట్టుకుంటే ఏమవుతుంది, నీకు మినిమం టైం ఎంత పడుతుంది, 18 months, 1 year to 18 months. సో ఇప్పుడు నేను దాన్ని లిబరలైజ్ చేసి నువ్వు డైరెక్ట్గా కోపం వస్తే కొట్టుకొని విడిపోండి, ఓకే, దానివల్ల నాకు పెండెన్సీ ఆఫ్ కేసెస్ తగ్గుతాయి. అందు గురించి నేను ఏం చేశాను, ఈ క్లాజ్ని నువ్వు యూజ్ చేసి లోకల్ కోర్ట్స్కి వెళ్ళక్కర్లా, డైరెక్ట్గా ఇద్దరు కలిసి మ్యూచువల్ కన్సెంట్తో వెళ్తా అంటే హిందూ మ్యారేజ్ యాక్ట్ కింద ఈ క్లాజ్ని నువ్వు పట్టించుకోకుండా అంటే యూ కెన్ సబ్సైడ్ దిస్ క్లాస్. వాట్ ఈస్ దిస్ క్లాస్? ఇర్రిట్రీవబుల్ బ్రేక్ డౌన్ ఆఫ్ మ్యారేజ్ అండర్ హిందూ యాక్ట్. ఇఫ్ యూ గో అండర్ హిందూ యాక్ట్ ఇట్ విల్ టేక్ అరౌండ్ 18 months. అదే, సో దిస్ ఈస్ వన్. నెక్స్ట్, సో బేసిక్ అంటే దేర్ ఆర్ సర్టెన్ కామన్ సెన్స్ వన్, దేర్ ఆర్ ఫ్యాక్చువల్ వన్స్, దేర్ ఆర్ కాన్సెప్చువల్ వన్స్. ఓకే, టెక్నిక్స్ ఉంటాయి, మళ్ళీ ఇవన్నీ యూజ్ చేసి మల్టిపుల్ పర్ముటేషన్స్ కాంబినేషన్స్తో ఈ స్టేట్మెంట్ రైట్ రాగానే మనం ఫైట్ చేసుకుంటూ వెళ్తే దేర్ మే బి పాసిబిలిటీ ఆఫ్ గెటింగ్ 90 score, 90, రైట్? నెక్స్ట్, ఇట్ ఈస్ పాసిబుల్ ఫర్ యూ టు అటైన్ 95+ as well if you can complete all these 1200+ topics and also your basic static component. Okay, next, granting divorce by the Supreme Court based on irretrievable breakdown of marriage is an absolute right for the parties involved. Is it an absolute right? By default you can use, if I use must, if I use compulsory, if I use absolute, can I demand Supreme Court? So how can I say it is my absolute right? It is a choice given to you by the Supreme Court to reduce burden on itself and at the same time to make you free from very some disturbed relationship, strained relationship. That's it. So common sense. Article 124 of the Constitution establishes and constitutes the Supreme Court. Okay, and it doesn't establish Supreme Court. It only allows the Supreme Court, what do you call, with respect to recruitment. Ever Chief Justice, ever gaadu. Next, 137 and 136 special leave petition. 136 is about providing Supreme Court with the authority to review its own judgment. 139 court of record. 139. So these are basic articles. Why should I read these articles again? Because these were mentioned here, 124 and 131, 137 in the article. ఇవన్నీ కూడా యూజ్ చేసింది ఎవరు? సుప్రీం కోర్ట్, while giving judgment in this irretrievable breakdown of marriage related term. Okay, under which article Supreme Court considered various elements? Under which article? 142. So to do complete justice under 142, what does Supreme Court do? It can use other articles, it can use its conscience, it can use due process, it can use fundamental principles of natural justice. Okay. Next. Next article is about protection from arrest extended to central armed police deployed in Jammu, Kashmir and Ladakh. So what is this protection? It is protection given to whom? Not people. It is protection given to paramilitary forces. Not only the armed forces, but also paramilitary forces. What are paramilitary forces? CRPF, BSF, Assam Rifles, Coast Guard. These are paramilitary forces, right? And ITBP, Indo-Tibetan Border Police Force. These are part of paramilitary forces. Okay, Border Security Force, all are. So, the paramilitary forces which are deployed in the conflict zone across various borders of our country may be protected under CRPC action. Suppose this is section 45. What is this? Section 45. Center has extended protection from arrest to whom? These paramilitary forces under section 45 of the Code of Criminal Procedure, to the personnel of the Central Armed Police Forces and all armed forces of the Union of India who are deployed in Union territories of Jammu and Kashmir, Ladakh region. Right? So, what may be the possible inference that you can draw with respect to UPSC? What were the questions asked previously with respect to detention? Okay, Unlawful Activities Prevention Act. With respect to this, what do you call? Prisons. Who will administer the prisons? Okay, Prisons Act. Okay, 1894. All these were asked by UPSC last year. Okay. So, legal cases can still be registered against personnel. So, when a paramilitary a person who is a CRPF Jawan inquiring into any criminality of an individual, he will not be charged under this article, section 45 of this CRPC. Okay, he cannot be arrested. But he is trespassing into your territory. You have any personal rivalry, you can go for legal case. Are you getting? You can file a case against this person who is part of this paramilitary force deployed in the region of Jammu and Kashmir, but he is trespassing into your private premises under private grounds without having any legality behind it. Therefore, they can be charged, but it is very difficult to prove. That is also very important. So, what are the facts associated with it? So, previously, before abrogation of Article 370, what was the penal code followed in the Jammu and Kashmir region? Did they follow CRPC, CPC, civil procedure? No. So, one of the penal provisions that they had adopted, this was passed previously, before independence itself, in 1930s, 40s. So, the code was Ranbir Penal Code. Okay, before abrogation of Article 370, what was the code? Ranbir Penal Code. So, Ranbir Penal Code, which was applicable there, but after this one, what happened? After this one, what happened? Can somebody tell him to come inside once? Run out. Okay. So, this is Ranbir Penal Code, which was applicable before abrogation of Article 370. But later, this CRPC was induced, and this under CRPC, section 45, the armed persons, the armed forces, not only the armed forces, but also the paramilitary forces who are deployed in the Jammu and Kashmir region are protected from arrest. Okay. During what happened? So finally, this criminal procedure code, commonly called as CRPC, is the main legislation which was administration or substantial criminal or something. It was enacted in 1973, which is not required actually with the lens of UPSC. So CRPF, that you have known, it is one of the paramilitary forces out of 7 forces: Indian Coast Guard, Indian Indo-Tibetan Border Police Force, Border Security Force, Assam Rifles, okay, and these are part of SSB or paramilitary forces. Okay. So what may be the possible question out of this one? Which of the following statements are correct regarding recent extension of protection from arrest under section 45 of Criminal Procedure Code to persons deployed in the region Jammu and Kashmir and Ladakh? Here, legal cases can still be registered against the personnel, but their arrest now requires following additional legal processes. Yes, if somebody is trespassing into my private premises, I can file a case against him. But he may be armed personnel who is deployed in Jammu and Kashmir region. He may not be prosecuted under section 45. No, there may be legal proceedings against him. You have to prove that he is not under duty and it is not part of his duty to enter into my private premise. You have to prove that one. So additional legal proceedings are required with respect to this person who is a paramilitary person. Are you getting? What is this additional legal proceeding? What is this additional legal? That you need to prove he is not concerned with his duty. He has his personal rivalry or something in conflict between us. So you need to prove that it is purely non-duty oriented, right? That one. Next, so additional legal process is required. Next, earlier this protection was applicable only to the armed forces. Earlier it was applicable to only armed forces. Now it is applicable to paramilitary forces as well. Next, the protection was previously applicable to J&K due to the Ranbir Penal Code under 1989. So the extension, why 1989 Ranbir Penal Code was amended? Because it came into picture in 1936, actually before independence only, but it was amended in 1989 because that illegal eviction of Pandits took place in 1989 itself. Therefore, so that the paramilitary forces were deployed in the region of Jammu and Kashmir, and also conflict happened in various aspects, right? Next, the protection was previously applicable to Jammu and Kashmir due to, yes, Ranbir Penal Code. Next, the extension of protection. If I ask you any statement that under section 45 of Ranbir Penal Code, which is exclusively applicable to Jammu and Kashmir, the paramilitary forces are protected. If I ask you that question, then you can comfortably eliminate it. If you have read it based on your facts and analysis, you can make it correct or wrong. Okay. So I have given you various permutations and combinations of making one statement is correct or incorrect. Okay. Next, the extension of protection was proposed after the repeal of Article 370. Extension was proposed after repeal of Article 370 of the Constitution of India. Ministry of Home Affairs considered this proposal and also agreed to these proposals that this extension may be possible because of the recent conflicts that have been continued after abrogation of Article 370, and not only to this extension applicable to armed forces but also paramilitary forces under CRPC instead of Ranbir Penal Code. Next, as per CRPC section 45, no member of the armed forces of the Union can be arrested for actions done in discharge of official duties without consent of the central government. Yes, so it may appears to be very arbitrary, but when it comes to on POTA, TADA and UAPA, unlawful activities prevention act something. So these cases, when they are dealing with these terms, so there may be certain terms which are arbitrary in nature. Recently in last year 2023 as well, they have asked the questions related to it, right? I'll tell you what are the questions though. I'll display them. India has operationalized this. Next, coming to fourth question, fourth or fifth article it seems. Next, India operationalizes Myanmar Sittwe port. Myanmar Sittwe port operationalizing. What is this Myanmar Sittwe? See here, Kaladan multimodal transit transport project. What is this multimodal term? Because it can use sea route, it can use naval route, it can use road and railway. It is a multimodal transit transport project, and it came into picture after an agreement between Indian side and also Myanmar side. And next, departure of the recent inaugural ship, that is from Shyam Prasad Mukherjee port in Kolkata. It can reduce the distance between Kolkata and Aizawl by about 1000 kilometers. because the pressure on Siliguri corridor will be reduced by incorporating this transit transport model, which is multimodal one, Kaladan multimodal. So, how will be the sea route here? Through sea route, you can do some journey 539 kilometers here from Kolkata, that is Shyam Prasad Mukherjee Port, to Sittwe, which is located in Myanmar. From Sittwe, it is Kaletwa. They are also part of Myanmar. After reaching the Kaletwa, you will be reaching this Mizoram, that is located, the name is, the entry place is Jorinpui. And next, you will be going towards, after reaching this Langklai and Aizawl. Okay. Here, through Paletwa, from Sittwe to Paletwa, you will be using which mode of transport? No, here sea route you will be using. Here you have inland waters, and next you will be having railway route and road route. Okay, that is why it is called as transit multimodal project. So Myanmar. So it is an initiative part of Kaladan multimodal transit project. What are the key highlights in it? The port connects to Paletwa in Myanmar through an inland waterway from Paletwa to inland water. What I have said? Inland waterway. And from Paletwa to Jorinpui in Mizoram through a road component. Have you got what I have said? Okay. Port is connecting to Paletwa. That is naval route. Okay. In Myanmar, again through, you are catching inland waters. Through inland waters, you are reaching Paletwa. Paletwa to Jorinpui. Jorinpui is located in Mizoram through road component. So, Kaladan multimodal transit transport project. Next, the port built under grant assistance from whom? Indian government. And it has been developed under framework agreement between India and Myanmar. Okay. And recently, in the first transit transport model from Kolkata to Sittwe, it has shipped around 20,000 bags containing 1,000 metric tons of cement. Okay. They are expected to reach Sittwe, already they have reached. So the port will open new opportunities for trade and transport are okay. That is about mains orientation. That is not required. Our fully operationalized this Kaladan multimodal transport transit project will provide alternate connectivity for the northeastern state, which can reduce some cargo traffic cost. Okay, these are the benefits. You can write benefits with respect to mains orientation. Next, Kaladan multimodal transit project is jointly identified by whom? India and Myanmar. So suppose if I ask you a question related to Kaladan multimodal project, if I ask you a question like, Kaladan project aims to connect the Eastern Indian seaport of Kolkata with Sittwe seaport, Rakhine state. Yes, it is Rakhine state in which Arkaniyoma mountains are located. Okay, are extended here only. Next, Myanmar via sea. The Kaladan project focuses on creating a high-speed rail link between India and Myanmar. No. Next, the Kaladan project aims to establish a direct road connection between Kolkata and Mizoram. No, it is one of the components only. Next, Kaladan project is primarily funded by Ministry of Defence. Actually, Ministry of Defence is funding whom? BRO, Border Road Organization. Okay, Border Road Organization is funded by Ministry of Defence. So next, choose the correct statement. You no need to give option A, B, C, D because there is no chance for elimination now. Okay, you should prepare that there is no chance for elimination for 100 questions. Next. So it will reduce distance from Kolkata to Mizoram by approximately 1000 kilometers and travelling time will also be reduced here because 3 to 4 days for transport of goods. Next, Union government takes control of whom? Manipur security. You need to remember two things, that ethnic tribes and possible questions that I have identified already mentioned here. Ethnic tribes, legal provisions to protect their customary laws and practices and various constitutional safeguards given to them and related articles. Okay, so they will not ask you questions how many people were died in their conflict, right? Generally they don't ask. So but it is important. What is important here? Here, see the important constitutional safeguards and provisions and legal protection given to their customary practices. And next, ethnic tribes located in that region and the major point of conflict between those ethnic tribes, right? Here, what is, and remaining all aspects are not required. Only thing required here is Article 350 of the Constitution. What is this Article 350 of the Constitution? The conflict arose in there. When the conflict was arisen, what was the immediate effect that government of India took? It has come into picture. What was the immediate effect that came into picture constitutionally as well? Article 355 first. Before imposing Article 356, that is presidential rule in the state, what should they consider? Article 355. Okay, they have to check whether this state is under constitutional machinery or not. Any internal disturbance is happening in the state, they have to check under Article 355. If Article 355 is supporting, then president rule can come into picture under Article 356 through a notification. Okay. Next, Article 355 refers to the provision in the Constitution that states that it shall be the duty of the Union to protect every state against external aggression and internal disturbance. It was removed actually armed rebellion only. Okay, after 1978, 44th Amendment, armed rebellion. Next, to ensure that government of every state is carried on in accordance with the provisions of the Constitution. Okay, if it is not going according to the provisions of the Constitution, then only you can impose Article 356. Next, so 355 is part of emergency provisions only under 18 of the Constitution, part 18 of the Constitution. Next, it is empowering central government to take all necessary steps to protect state against this internal disturbance. So what may be the possible question here with respect to 355 of the Indian Constitution? Article 355 mandates the Union government to safeguard every state against external aggression and internal disturbance. Okay, ensuring the compliance whether they are complying with the constitutional provisions. Next, 355 is primarily concerned with the emergency provisions related to financial matters. No, absolutely not. This is 360. Next, Article 355 empowers the state government to handle law and order situation independently. So, what may be the possible one? Only one. Okay. Next, coming to this, Border Roads Organization Project Dantak to commemorate the 64th Raising Day. What is this Border Road Organization? You need to learn about this, bro. Prime Minister has praised this Border Road Organization. This is also one of the prominent organizations that has been contributing so much to the integrity of the nation. That is Border Road Organization. It has achieved various milestones. For example, the milestone that is Atal Tunnel, Atal Setu. Okay. Now this one. What is this Atal Setu? And Kol Chewang Rinchen Setu, to name a few. What is this Kol Chewan Rinchen Setu? It is located in Ladakh, just 45 kilometers away from the Chinese border, and it has built a cable bridge, okay, which connected and which was very strong and which is high altitude in nature, one of the highest positions in the world completely. And next thing is, bro has got this Guinness World Record in November 21 for the highest altitude road, that is at Umlingla, highest altitude road, and it is instrumental in constructing some of the great engineering marvels like Atal Tunnel and Atal Setu. Where is this Atal Setu is located? Atal Tunnel is located. Very good. That, see, what is meant by tunnel and Setu? Setu means a bridge. It is not a way. Okay, the bridge is not about 100 kilometers, 200 kilometers. Just it is about meters. Okay. The meter, that is, but why they consider it as one of the marvels, that milestones? Because of its locational factors. See, this project Dantak was actually, with respect to project Dantak, I would like to tell you one more statement. It was established in 1961 and as a result of an agreement between the Bhutanese president, okay, Bhutanese monarch, and India Prime Minister Jawaharlal Nehru. Jigme Wangchu was his name during that time. Present Unnodiki Tata. Okay. Next, it was established under the provisions of Indo-Bhutan Treaty of Peace and Friendship 1949. So, ఇప్పుడు మీకు అర్థమైంది ప్రాజెక్ట్ దాంతక్ ఎవరికి సంబంధించింది? భూటాన్కి. ఎవరికి? The project involved identifying most important aspects of connectivity and so for the socio-economic development of whom? Bhutan. Okay. Task to construct and maintain roads suitable for motorized transportation in Bhutan. So what is this border road organization? That I would like to tell you this one as well. So these are, you need to pick only the relevant points here. Project Dantak, next border road organization, next its contribution, Atal Setu, Atal Tunnel, Ranchi something, sorry, ఏదో ఉంది కదా name తిరగకుండా అది. So border road organization is a statutory body under ownership of Ministry of Defence, Government of India. This is one. Next, it maintains new networks and roads across border areas, border regions, and especially for friendly neighboring countries. And next, this includes infrastructure operations in 19 states and 3 union territories. 19 states and 3 union territories. Even it also contributed for Sri Lanka. Okay, 19 states. And also neighboring countries here are Afghanistan, Bhutan, and Tajikistan, Sri Lanka, Myanmar. Next, organizations. Here, organization motto is Sremena Sarvam Sadhyam. Everything is achievable through hard work. Organization motto. It is very relevant for us as well. So everything is achievable through hard work. Sremena Sarvam Sadhyam. Next, BRO is instrumental in signifying upgrading its skills and building new China road borders as well. Indo-China border roads. Here, BRO is getting these many world records. Guinness World Record is one of this one. High altitude road. It was built at Umlingla. It is also located in Ladakh. Okay. And next one is what is called Dantak. Yeah. Coming to number of questions that may be possible here. Coming to number of questions that may be possible. Possible number of simpler questions to complex ones, because instead of giving you complete complex questions, I have segregated these complex questions into simpler ones. Therefore, you can observe that before 10 years, the questions were like this. 10-12 years back. So questions were 100 MCQs only. Let's consider 2011 paper, 2012 paper. Questions were around 100. Now questions are 400 under the umbrella of 100. Simple. Question. That is why people are unable to maintain some time management. They are facing problem of time management in the original examination. Because they are reading 400 questions within these 2 hours. Okay. So like this, they have segregated, they have combined these segregated questions of 2012-11 model. So now you can realize that you will be attempting 400 questions in 2 hours. So for example, in 2011-12 model, if you find the number of minutes that you spend for each question is around 1 minute. 1 minute or 1 minute 20 seconds. Okay, and distribute this 1 minute 20 seconds for 4 questions. 1 minute 20 seconds for these 4 questions. Therefore, you have to attempt these 4 questions in just 1 minute 20 seconds, not more than 1 minute 20 seconds. Have you got my point? If you see this simple question, you should be able to answer it within 15 seconds. Therefore, you can be able to solve that complex question within 1 minute 20 seconds, and you can save some time and energy. Okay, because I am not considering your thinking time in the examination hall. I am only considering your reading comprehension. To spend some more time, to give some time for your thinking competency in the original examination, you have to confine it to 1 minute. Because these 20 seconds are precious for you to enhance your scores in the examination hall. Because you will be encircling few tougher questions which will be seen later at the end of the exam. But by the time you won't be having any time. So to save at least 10 minutes time, your reading comprehension should be faster. Coming to this question, you should be able to answer them within 10 seconds. 10 seconds marathon. Project Dantak was established as a result of an agreement between. Okay. Next, the primary purpose of Project Dantak is to. So you have to read all these 4 options immediately. So develop infrastructure in India's border areas. Next, construct and maintain roads suitable for motorized transportation in Bhutan. Yes. Next, the motto of border road organization is everything is achievable through hard work. Okay. This is which of the following countries does the BRO operate in? Yes, that is project operate in India and Bhutan previously, now not now. For Pakistan, for Sri Lanka, for Nepal, it is not working. Okay, at present, but it had. I have to mention here is Dantak actually. Okay, I have to mention here Dantak. And next question may be possible one. For how many states across the border road organization contributed, and how many union territories as well? Yes. So these are the facts that you need to remember through MCQ format. Okay. Next, but reading comprehension should not be more than 10 seconds for simple MCQ. For complex one, not more than 1 minute. Therefore, you need to segregate each statement into one MCQ. Next, 10 Indian languages to get technical term dictionaries. 10 Indian languages. What is this technical term dictionary? This is a commission for scientific technical term dictionary working under the aegis of Ministry of Education. How will you use this one? Because you can use this for new education policy, because this more assumes importance as new education policy, which is emphasizing on native language. Okay, education in the mother tongue. So this commission for technical terms development, this is that is called jargon, subject related jargon development, that is being done by whom? This commission for scientific and technical terminology. It is working under the aegis of Ministry of Education, but you may consider it may be under various other ministry, but it is exclusively contributing to people who are studying in various schools and colleges and for various competitive exams as well. Like UGC is giving that authority to one third party, that is National Testing Agency. It is conducting various exams for central universities and also other exams like National Eligibility Test. Okay, and one more thing, that is Joint Entrance Examination, JEE main. This is and University Grants Commission, National Eligibility Test to aid preparation for content, and Central University Entrance Test. These are conducted, right? So they have to provide this content in their mother tongue as well, in as many scheduled languages as possible. For that purpose, the assigned task is to whom? The task is assigned to Commission for Scientific and Technical Technology, which works under the aegis of this Ministry of Education. It is to create technical scientific terminology in 10 Indian languages at present. Okay. So the fundamental dictionaries with 5,000 words per language in 3 to 4 months is the task given to them, and it has developed more than 5,000 words for each language. The 10 languages were assigned to it. So very soon it will be coming up with various other exams, like all the competitive exams. Like already Railway Recruitment Board has introduced the exam in not only English but also not only Hindi but also in regional languages, Telugu, Tamil, Kannada as well. Next, this which was set up in 1961. This is, what is this called? Commission for Scientific Technical Terminology Development 1. So it was set up in 1961, has the mandate of evolving technical terminology in all Indian languages. Actually, it has mandate to develop this technical terminology in as many languages as possible. At present, it has potentiality or capability to build only for 10 Indian languages, this technical terminology. So there is a memorandum of understanding happening. This is not required. Next, coming to this next article, a High Court doesn't have power to direct changes in scheduled tribes list. One more thing that I have to actually display, but my laptop was not here. Okay, I will tell you, but I have developed some content regarding this one. Question in 2019, there was a question with respect to scheduled areas. Okay, if a land is ascribed to, or if a land is coming under Schedule 5 of the Constitution, what will be the possible impacts? So it will not be given to any private party for mining purpose or any commercial exploitation. It should be held in the hands of the traditional forest dwellers only in that region who are residing, who have been residing for many generations. Okay, the same question, the option was given as question in 2022. 2019, the option of 2019 with respect to 5th schedule was given as question in 2022, And the question in 2019 was given as option in 2022. Just it was reversed. Okay. It is very easy to find out the probable questions from PYQs. Many questions. Line-tailed macaco was asked several times. Okay, last year they have asked line-tailed macaco, but without elimination. And apart from all three statements, Malabar civet, line-tailed macaco, these were given last year only, and previously they have asked regarding these endangered species, but without elimination. They were actually very simple. Okay. Next, coming to this, High Court doesn't have power to direct changes in scheduled tribes list. Therefore, based on our previous experience, I am coming with it. 2023. Sorry, I have forgot to tell you what is the content that I have developed. Again, in 2023, they have asked question related to scheduled areas. Okay, with different orientation. You please go through this 2023 paper, 22 and 2019. Scheduled areas was one of the favorite areas of UPSC. Okay, scheduled areas. So, a High Court doesn't have power. I will share it in Telegram channel. What was the research that I have done with respect to these scheduled tribes. Here it is not there to display. So, when I have set an MCQ as well, what is this MCQ? After reading this one, I will tell you what are the possible MCQs out of this. Yeah, yes, I have. Regarding the inclusion of Meitei community in scheduled tribe list, which statement is true? Which statement is true regarding Meitei community to include them in scheduled tribe list? What are the basic parameters required, and who has the power to include them? Include any of you in scheduled tribe list. Who has the power here? The Manipur High Court directed the state government to include Meitei community within 4 weeks. Regarding the inclusion of Meitei community in scheduled areas, tribes, which of the statement is true? So actually they may not be asking this Manipur and controversial aspect, but it is not controversial, it is only subject oriented only. But I am telling you this contextual sensitivity for your convenience only. Okay, Meitei. This first statement is fine because the judgment was given, therefore the conflict erupted after this judgment only. By keeping this judgment in mind, what did this Supreme Court tell? What was the verdict it has given? Supreme Court? See, actually to include somebody in the scheduled tribes, it should be notified by whom? President of India. Before notification coming into picture, under which article again? There are articles under Article 342. Article 342 में 2 classes है. Article 342 class 1, class 2. Okay. So before this notification came into picture, there should be a procedure that should take place in which Parliament, after the bill was passed and the consent was given in the Parliament only, same should be replicated in the notification given by the President. There should not be any alteration as well. Okay, this should be the procedure. But what happened with respect to Meitei community to be listed under scheduled tribes and within 4 weeks you have to give me a report? High courts should never interfere into legislative and executive actions which had to be taken place in the Parliament and later notified by the executive action, that is by President. This is a basic dispute happened there. So what are the things that you need to remember here? Possible questions: ethnic tribes, constitutional safeguards and provisions, and various customary laws and practices that they have been practicing, right? These are the only potential themes that you need to identify. So coming to this one, Article 341, Class 1, Class 2, coming to this. Article 342, 341, Class 1, Class 2. Here, yeah, as per Article 342, Class 1 of the Constitution, it is presidential power to designate, it is whom? Presidential power to designate a scheduled caste or tribe. Whether you belong to scheduled tribe or not is being designated by whom? President. You cannot claim yourself, or High Court should never interfere. Second thing. Next, Chief Justice of India said that the Constitution bench in state of Maharashtra versus Millen, state of Maharashtra versus Millen, had held in November 2000. It is High Court has referred this one. Okay, sorry, Chief Justice of India. Chief Justice of India has referred this one. Which one? Maharashtra versus Millen case in 2000. It is not open to state government or courts. It is not open to state government or courts or tribunals or any other authority to modify, amend or alter list of scheduled tribes. Even ST commission is there. It cannot alter. It can only recommend. Ultimately, it has to be done by presidential notification only. Okay. Until the notification issued under clause 1 of the article 342. Under article 342 clause 1 only, a person will be designated as scheduled tribe or scheduled something. Okay. And constitution bench held that notification issued under this clause 1 of article 342 specifying scheduled tribes can be amended only law that has to be made by whom? Parliament. Law must be passed by Parliament. Next, the constitution bench held that scheduled tribes order that had to be read as it is. Scheduled tribe order has to be read as it is. What is this order? Order means execution act. Okay. The law what is passed in the Parliament has to be replicated as it is. It has to be read as it is. Next thing. The settled law in the Millen verdict, that is State of Maharashtra versus Millen in 2000, which was reiterated by Chief Justice of India in this verdict had been referred by July 2017 judgment authored by Justice Chandrachud. And it is a 3-judge constitutional bench. And one more case, that is Supreme Court in CMD FCI versus Jagdish Balram Bahira. CMD FCI versus Jagdish Balram Bahira, to note that the presidential order under Article 342 regarding scheduled tribes were always final. Presidential order was final. There should not be any alteration, no interference. If somebody puts files a case against the presidential order under Article 342, then immediately the High Court or concerned High Court should refer it to whom? Only the President. Okay. So, it cannot order the President to notify meeting under this one. Okay. Or it should never go against it. Something else, it should never interfere, it should never order. It should never give any verdict. There is certain procedure, legal procedure, legislative procedure here. So, next, Article 341 and 342 of the Constitution of India defines as to who would be scheduled caste and scheduled tribes with respect to any state. Article, fact is 341 and 342 defining who would be scheduled caste and scheduled tribes. This is Article 341, 342. Actually, with respect to scheduled tribes, 342 clause 1, that is presidential notification. If Parliament has passed a law, but presidential notification hasn't come into picture, still you cannot designate one person as scheduled tribe. Okay. If President has notified, but there was no law passed behind it, it should never be implemented. Then you can go to court. Okay. You can go to court if any of these predecessors was not taken place. Any of these predecessor procedures were not taken place, then you can approach the court. Okay. Next. What is this? The President may, with respect to any state or union territory under Article 341 clause 1 and caste, tribes and are parts of groups within caste, races, tribes, the President may designate under this Constitution and with respect to union territory as well. Parliament under Article 341 clause 2, Parliament may by law include or exclude from the list of scheduled caste specified in notification issued under clause 1. Under clause 1, Parliament can amend that notification. Okay. With re-notification, you cannot amend through executive order. Ultimately, presidential order is executive order. With re-notification, you cannot do. The notification is nothing but implementation of the law passed in the Parliament. It is not having any power to alter the law passed in the Parliament. Simple. Okay, so the tribe part of group with any. Next thing, 342 clause 1. President may, with respect to any state, union, territory, after consulting the governor by public notification, specify the tribes or tribal communities are parts of this group, and they may be designated as scheduled tribe or something. Okay, under this one. Now you can answer any of these questions, like not more than 5 seconds for each one. Not more than 5 seconds. So regarding the inclusion of Miti community in the scheduled tribe list, which statement is true? The Constitution bench state Maharashtra Million held that state government have the authority to modify the list. Next, Constitution bench held that scheduled tribes order can be amended by any authority. Next, presidential order under Article 342. Yes, regarding scheduled tribes is always final. Okay, it has taken 10 seconds. No. Next, who has the power to designate a scheduled caste or tribe as per Article 342 Class 1? Who has power? That's it. Directly you can come to a conclusion. Next, according to Constitution bench, in state of Maharashtra versus Mill, what is the correct statement? State government can modify scheduled tribes. State government cannot modify. Next, scheduled tribes, order must be read as it is. Yes. Order must be read as it is. No interpretation. What is mean by order must be read as it is? ఏదో ఒక కోర్టు తీసుకొని నాకు నచ్చినట్టుగా నువ్వు ఇంటర్ప్రిట్ చేస్తా అంటే కుదరదు అని తిట్టడం. నువ్వు అది ఏది ఉందో అట్లనే చదువు, ఎక్స్ట్రా చేయొద్దు, ఎక్కువ మాట్లాడద్దు, ఎక్కువ దాని గురించి నువ్వు కొట్టివేతలు తీసివేతలు కలపడాలు ఇవన్నీ చేయొద్దు అని చెప్పింది ఎవరు? స్టేట్ ఆఫ్ మహారాష్ట్ర వర్సెస్ మిలింద్ కేస్ ఇన్ 2000. Okay, which authority can amend the notification specifying scheduled tribes? I hope this question may come in 2024. ఎందుకంటే షెడ్యూల్డ్ ఏరియాస్ గురించి 23లో అడిగా, 22లో అడిగా, 2019లో అవే స్టేట్మెంట్స్ తిప్పి అడిగిన ఉన్నాయి, ఆ థీమ్ బేస్ మీద అడిగాడు. సో there may be possibility. Next, which authority can amend the notification specifying scheduled tribes as per the Constitution bench? Which authority here? Next, Article 341 to 42 of the Constitution pertains to C. Is it powers of the president? No. It is about definition of scheduled caste and scheduled tribes. Right. India leads list of 10 countries with 60% of global maternal deaths, stillbirths, newborn deaths, UN study. So, but you need to remember one thing, that 60% of global maternal deaths, stillbirths, newborn deaths are taking place. India leads list of top 10 actually. Okay, what is this list? But number of births, 100 మంది పుడితే 17 మంది ఎక్కడ పుడుతున్నారు? ఇండియాలో పుడుతున్నారు. ఓకే కదా? సో మనిషికి ఫస్ట్ పని ఏంటి? తిందో, నెక్స్ట్ కండం అని పెట్టుకున్నారు వాళ్ళు. 100 మంది పుడితే 17 మంది ఇక్కడే పుడితే మరి చనిపోయే సంఖ్య కూడా ప్రపోర్షనేట్గానే ఉంటుంది. సో అందుకే ఆ పాయింట్ కూడా మెన్షన్. యూఎన్ స్టడీస్ ఏం చెప్తే ఇప్పుడు అది లేదు, ఇది లేదు, అది లేదు, ఇది లేదు అని తిడుతూ ఉంటాయి. కానీ 150 crore పాపులేషన్. ఓకే, సో మరి ఫ్యూచర్లో వాళ్ళందరూ పాపులేషన్ తగ్గిపోతే యూరోప్ అంతా ఇండియా అయిపోద్ది. ఎంపీలు ఎమ్మెల్యేలు కంటెస్ట్ చేయడానికి కూడా మన వాళ్ళే ఉంటారు అక్కడ. సో ఇప్పుడు ఇక్కడ ఏంటంటే, సరే నేను దట్ ఈస్ వై ఐ హావ్ మెన్షన్ దట్ స్టాటిస్టిక్స్ యాజ్ వెల్. ఓకే, కంపేర్ టు. సో అకార్డింగ్ టు ద ఫస్ట్ ఎవర్ జాయింట్ ఎవ్రీ న్యూబోర్న్, దిస్ ఈస్ ఈనాప్. ఓకే, న్యూబోర్న్ యాక్షన్ ప్లాన్, ఎవ్రీ న్యూబోర్న్ యాక్షన్ ప్లాన్ and ending preventable maternal mortality progress tracking report. The global progress in reducing deaths for pregnant women, mothers and babies has flatlined for 8 years due to decreasing investment in maternal newborn health. After 2015, in India's case also, these newborn deaths and stillbirths increased after 2015 as well. But after COVID-19, the funding for this funding to reduce this maternal mortality and infant mortality was also reduced after COVID pandemic across the world, not only in India, across the world. So global challenges posed by COVID-19 pandemic, climate change and conflicts, other emergencies as well. Cost of living increases with countries, and this is leading to slow progress in this decade for last 8 years. Why? 60% of these newborn are facing stillbirths, underweight, undernourishment, all these things because of these issues. The conflict has been tremendous for last 1 decade compared to previous ones. And climate change impact, and also the conflicts and pandemic, which is very disastrous in situation across the world. Next, funding shortfall on underinvestment in primary health care can also devastate was also a devastating situation for the prospects and report highlighting this one. That UN study, the UN study was done by whom? What is the study? Every newborn action plan and ending preventable maternal mortality. So what is this? India saw 7,88,000 maternal deaths, stillbirths and neonatal deaths. Okay, India saw 7,88,000 maternal deaths, stillbirths and neonatal deaths in 2020. Out of total 4.5 million deaths across the world. 4.5 million deaths. But you need to account this one as well. You need to account that 17% of global live births. India accounting for around 17% of entire global births, which could be a factor for the large number of maternal deaths, stillbirths and neonatal deaths. So I have to balance this one to tell you that you have to balance this answer. You cannot criticize completely India directly, right? There is no effort has been taken place. Is it true statement? Poshan Abhiyan is also there. Midday meal scheme is there. Scheme, one of the successful projects. Public distribution system, successful project. Antyodaya, successful project. For there are several direct benefit transfer schemes which are taking place for many years, many decades. So it is very clear that the number of births taking place in India is around 17%. Therefore, out of 4.5 million births across the globe, how many stillbirths, maternal deaths in India? 7,88,000. So compared to this one, this is lesser, isn't it? Next, Jan Suraksha schemes complete 8 years of providing social security cover. This is also fine, important and several times asked. What is this Jan Suraksha? Jan Suraksha Bima Yojana and Pradhan Mantri Jeevan Jyoti Bima Yojana, Atal Pension Yojana, and one more Yojana is also there. What is this? Pradhan Mantri Suraksha Bima Yojana, Jeevan Jyoti Bima Yojana and Atal Pension Yojana. Okay, last way. What are these schemes? Actually, it was launched in Kolkata in May, when Prime Minister of India came into power for the first time in 2015 in West Bengal. 16.2 crore people, 34.2 and 5.2 respectively. Pradhan Mantri Jeevan Jyoti Bima Yojana, Pradhan Mantri Suraksha Bima Yojana and Atal Pension Yojana. Okay, 16 crore people subscribed to this one and 34 crore for Pradhan Mantri Suraksha Bima Yojana. What is this Pradhan Mantri Suraksha Bima Yojana? It is an accidental death cover of 2 lakh rupee per head. Okay, per annum premium is 12 rupees. Okay, in the initial times. Next, what is this Pradhan Mantri Jeevan Jyoti Bima Yojana? It is life insurance, a kind of life insurance. What is the premium that has to be paid by each one? Around 462, 482, some amount is there. The amount is not important, per annum premium. Okay. Next, Atal Pension Yojana. This is for whom? Unorganized sector workers. Unorganized sector workers. And they may contribute 1,000 rupees to 5,000 rupees. 1,000 rupees to 5,000 rupees between age group of 18 to 40 years are eligible. If a person who is actually ascribing to this one, what do you call? Atal Pension Yojana, he has to pay for 20 years. He has to pay for 20 years. How much should he pay? Suppose if a person between 18 to 20 years, okay, every month he may be paying 20 rupees or 30 rupees. If a person is around 40 years, at the later stages of life, he is supposed to subscribe to this one, Atal Pension Yojana. He has to pay per annum 400-500 rupees. Double amount that he has to pay. Okay, there is a certain threshold for every month. After paying it for 20 years, whatever may be the age, if a person starts paying by the age of 20, for 20 years he contributed something from his pocket for Atal Pension Yojana. After his 60 years of age, after he attains 60 years of age, till end of his life, he will be getting proportionate amount per month as pension. Okay, if he is only paying 20 rupees per month for 20 years, okay, between 20 years of age to 40 years, he will be getting only 1000 rupees per month after his 60 years. If he is paying 100 rupees per month for 20 years, he will be given 5000 rupees per month pension. So it is, what does it mean? Simply, it is proportion, the pension reward will be proportionate to the contribution made by the subscriber. This is Atal Pension Yojana. Remaining things are simple. And Atal Pension Yojana is exclusively for whom? Unorganized sector workers. Okay, remaining accidental death and disability coverage life insurance will be for Pradhan Mantri Suraksha Bima Yojana, and Pradhan Mantri Jeevan Jyoti Bima Yojana can be subscribed by anyone, no problem. But with respect to Atal Pension Yojana, it is for whom? Unorganized sector workers. So it is not applicable to government employees or any organized sector, big MNCs who are okay working. So Atal Pension Yojana is administered by whom? Pension Fund Regulatory and Development Authority, PFRDA, is the administering authority of this. And under the overall administrative institutional architecture of National Pension System. You please remember these facts, okay? Who is administering this? PFRDA. Under the overall institutional architecture of this National Pension System. Atal Pension Yojana is open to all bank account holders in the age group of between 18 to 40 years. And benefit subscribers would receive the guaranteed minimum monthly pension of 1000 rupees to 5000 rupees. 1000, 2, 3, 4, 5. Okay, there are 5 components. After they attain the age of 60 years, based on the contributions made by the subscribers after joining the scheme. If you go to bank, sir, I am an unorganized worker, I would like to subscribe to this Atal Pension Yojana. What should be my contribution? Tell me your age. Simple. If you are at the age of 30, there will be some kind of contribution that you have to make. You want to make contribution for 1000 rupees or 5000 rupees. They will give you a chart. Okay. By choosing that chart, you can pay the amount accordingly, the premium amount. Okay. There is no particular fixed stipulated amount per month for each. Okay. According to the age, according to the interest to contribute something, they can choose the plan for Atal Pension Yojana. So according to that plan, they will get amount from 1000 rupees to 5000 rupees after they attain the age of 60 years. Next, this is Pradhan Mantri Suraksha Bima Yojana. It is every year you have to renew it. Renewal should be done every year. This is accidental insurance scheme, renewable from year to year, offering coverage for death or disability due to accident. Death coverage is 2 lakh and disability is 1 lakh. Next, eligibility persons in the age group of 18 to 70 years. For Pradhan Mantri Suraksha Bima Yojana, the eligibility age is between 18 to 70 years. Next, benefits. Accidental death cum disability cover is 2 lakh. For death, for disability due to an accident, that is 1 lakh in case of partial disability. For death or disability due to an accident against a premium of 20 rupees per annum. Okay, 20. For whom? Disability due to an accident against a premium. Suppose if I want to pay premium of 12 rupees per annum, I will get 2 lakh rupee insurance for my accidental death. Okay. If I pay 20 rupees per annum, not only for accidental death but also partial disability. So extra 8 rupees per annum. Simple. Next, Gopal Krishna Gokhale birth anniversary that had taken place in May times. Who is this Gopal Krishna Gokhale? Yeah, okay. This simple. His social reformer established servants of Indian society. First one, established servants of Indian society. And Gokhale led Congress moderate faction. He was a moderate, not extremist. And he was also a guru for whom? Tilak. Not only Gandhi, but also Tilak. You please kindly remember. That is why I have never taken his name. Okay, he went to South Africa, he met Gandhi, Gokhale, he preached something. Okay, Gokhale just born in 1866 only. Gandhi born in 1869. Okay, there is only age difference of 3 years between them. Okay, Surveillance of Indian Society. Next, but what do you call? Gokhale sought more political representation for Indians and wanted the British to respect the rights of Indians more. So, what was his moderate approach? These extremists did not want representation from British because this is not any concern or consideration from the British side. It is our birthright to represent ourselves, to have freedom to ourselves, right? So, however, Gokhale's primary focus was to represent Indians into the parliament, not only in Indian parliament but also British parliament. Gokhale's initial political career resembled that of Tilak, but their paths diverged later over differences in opinion about how to improve the lives of common people. And also one more thing, he was patronized by whom? He was prestige of whom? Mahadev Govind Ranade, one of the social reformers. His association with various people that I am telling you, his association with. He was a protege of social. Protege means somebody gave you asylum, some kind of. Asylum means not asylum, kind of more response, okay, more accommodative towards you. Okay, that is reformer Mahadev Govind Ranade. Okay, it's patronized this Gokhale. Next, some of his contemporary leaders were Bal Gangadhar Tilak, Dadabhai Naoroji, and Lal Bal Pal, Annie said. And Servants of India Society aim was to empower Indians to education, through education. It has worked more in the field of which sector? Education sector. Okay. Next, Indian Society for expansion of Servants of Indian Society for the expansion of education in India. So, what are the grey areas that I have missed? Okay, reached 1900. Gokhale 1905 became the Congress president. In 1905, he became the Congress president, and he established Servants of Indian Society with the aim of expanding education. Next, Gokhale became a member of Mahatma Gandhi, mentor of Mahatma Gandhi, when the latter was still trying his way amid myriad of Indian politics. What is the grey area that I have missed? It seems 1912, Gokhale went to South Africa. Already I told you, it seems. In which year I haven't said, but in 1912 he went to South Africa. And when Gandhi returned from Africa to India, Gokhale himself guided Gandhi. Next, even in his autobiography, Gandhi calls Gokhale his mentor and guide. Next, interestingly, after Gokhale died on February 19th, on 19th February, Tilak paid glowing tributes to him in an editorial in Kesari. Okay, that is also. ICOMOS, one more organization, that is International Council on Monuments and Sites. I have told you various international organizations that you need to remember. One organization that I had already discussed about, UNIDO, United Nations Industrial Development Organization. In collaboration with whom it has given some report, it has done some survey, manufacturing survey, innovation manufacturing survey. Karnataka topped in it. Just 1 hour ago we had discussed, immediately forgot. Okay, in collaboration with whom? Department of Science and Technology, United Nations Industrial Development Organization. Its headquarters is in Vietnam. How many countries permanent in? Permanent presence. 60. 70s, 60s. Appude 60. Next, number of total countries that have become members here. 170 by 2019 in United Nations. For the purpose, what is its function and major role? Contribute to the development of industrial sector in marginal countries, third world countries, developing countries. That is United Nations Industrial Development Organization. Okay. Now, in collaboration with DST, it has given report on National Innovation Manufacturing Survey. Karnataka was topping in that, and followed by Telangana and Tamil Nadu. Least performing states were Odisha, Jharkhand. Have you remembered everything, right? So, in the first article, you must have been very attentive. Okay, ICMOS, I am talking about ICMOS. Now, second, international organizations. What is this ICMOS? International Council on Monuments and Sites. International Council on Monuments and Sites. What does it do? There are certain sites which are listed as World Heritage Sites. There will be a committee behind it, World Heritage Committee. Who will recommend that committee to be listed under World Heritage Site? This International Council on Monuments and Sites. This will recommend World Heritage Committee to list certain areas under this one. Okay? International Council. What is Shantiniketan? Was recommended by whom? ICMOS. International Council for Monuments and Sites. It recommended Shantiniketan. It is located in West Bengal. And it was actually home for Nobel laureate Rabindranath Tagore. And it has been recommended for the inclusion in the under UNESCO's World Heritage Site. And Vishwa Bharati was one of the universities built by Tagore located in Shantiniketan itself. Next, the recommendation was made by International Council on Monuments and Sites. Okay, this is advisory body to the UNESCO World Heritage Center. Next, ICMOS is a France-based international culture body, France-based international culture body, which comprising various professionals, experts, even from local authorities and companies and heritage organizations. So, many stakeholders are involved. It is not taken from only United Nations or some organization. It is a France-based cultural organization, okay, in which many stakeholders are participating and partially selecting various sites across the world to be listed under UNESCO's World Heritage Site. It is an advisory body to UNESCO World Heritage Center. Okay, the World Heritage Committee will consider the opinion and recommendations given by ICMOS. So, okay, this is one. Next, in 2021, UNESCO has included Durga Puja in Kolkata as intangible cultural heritage. If Shantiniketan is listed under UNESCO's World Heritage Site, this will be the second one under UNESCO's World Heritage list. One is tangible and the other one will be intangible. Next, Delhi government announced a scheme to regulate cab aggregators, delivery service providers. So, one more thing that you need to remember, if a statement is given that the state government can regulate motor vehicle aggregators which can commute across various borders of the state, country, various interstate commutation. Suppose if I tell like that, for interstate, Delhi is exactly in the hot space, okay, hot spot. What do you call? Just within half an hour or 1 hour, you can go to Noida, which is a border region of Uttar Pradesh. Within half an hour or 1 hour, you can go to Haryana. Okay, so most of the motor vehicle aggregators which are registered across various states are also roaming in Delhi. So, can I control these motor vehicle aggregators which are operating across various states? So, simple, yes, you can. You can, how can you? It's under certain norms and conditions. Okay, for the security and safety of the passengers and for facilitating motor vehicle aggregators business. You can do various regulations. Even union territory, not only the state, even union territory able to do such a regulations, therefore automatically it will be done by whom? Even states as well, isn't it? So for that purpose only I have told you, if a statement is given like motor vehicle aggregators who are operating across various states in India will be regulated by only central government. Is this statement correct? No. Actually, if there is a parliamentary law passed and executed by central government, therefore no state government can subside that parliamentary law. If it is not notified by President of India, if any state law which is actually taking some consent, which has taken consent of the president. Therefore, the state law will prevail. If parliament has made a law, therefore central law will prevail. Isn't it? These are basic things. So, Delhi government announces schemes to regulate cab aggregators develop. Okay, what is it telling? This draft motor vehicle aggregator scheme 2023 aiming at regulating cab aggregators and delivering service providers in the city. What is the service? The scheme aims to achieve the twin objectives, prioritizing the safety of the passengers, already I have told you, and also encouraging electric vehicles. Okay, what is the scheme telling? 100% electric vehicle, bring 100% electric vehicles. It is incentivizing them. There will be zero license fee on the electric vehicles. If a motor vehicle aggregator is going to shift from petrol or diesel or CNG based vehicle to electric vehicle, their license fee will be zero. They won't be having any license fee. Okay. Next thing is the security mechanism for the passengers. Each motor vehicle aggregator must comply certain norms. That norm is mostly with respect to this panic button in all vehicles and integrate it with 112 Delhi Police Emergency Helpline. Okay. So every car, motor vehicle car or even Rapido bike as well, something, must mandatorily install a panic button in all vehicles and integrate it with 112 Delhi Police Emergency Helpline. These are the two things that were reforms brought by Delhi government only. Right. Next statement. Yeah. What are the other disputes happening with respect to Delhi Union Territory Capital? 239A. Already you might have known about this. Constitution bench headed by Chief Justice D.Y. Chandrachud, again reiterating National Capital Delhi. Okay. It would not have power to legislate on public order, law and police. It would not legislate on public order, law. So what does it mean? The Supreme Court on May 11 gave the Delhi government power to make laws and wield control over bureaucrats. So what does it mean? If a bureaucrat is working under both the governments, that is Delhi government and central government, must comply the regulations and norms given by Delhi government. They should not go against the orders given by Delhi government. However, if it is a police personnel, they should not comply to the regulations given by Delhi government. If it is related to law and order, they no need to agree to it. If it is related to whom? If it is related to land dispute, the order must not be valid. Then coming to this point, that is motor vehicle aggregators must imply a panic button for the safety of passengers. This was the ruling passed by Delhi government. Okay. Under something like public order or safety and security. Will it be valid? No. Not like that, because it is a scheme, it is a draft bill which is under proposal. You cannot say it is wrong, or you cannot say it is absolutely right. It is, what does it mean? It is a draft bill. This draft should become law. This law should never have any dispute with central government. If central government had no dispute, there won't be any kind of dispute arisen in the court. If dispute arisen in the court, it is a federal dispute or not semi-federal dispute. Okay. In this semi-federal dispute, who will decide finally? Like Justice Chandrachud only. Okay. Delhi government. If Justice Chandrachud or CJI or other judges feel it is interfering into public order, police and other land disputes areas which are exempted under the state list, that is entry 41 it seems. Entry 41 it seems. Okay, I will tell you which entry. So therefore, it will become invalid until it is decided by the Supreme Court. Until a dispute arisen between central and Delhi government, you cannot say it is invalid, because there is no much interference of the Delhi government into the law and order area here. because they are bringing some panic button as mandatory one. Okay, if it is affecting motor vehicle aggregators use economically, it may not be coming under this one. But if it is considered to be part of this land order dispute, then again it has to be resolved by Supreme Court only. Okay, this is just a draft bill. You cannot say it is absolutely true or false. So that is why attentive reading is very important while reading the article. What is this attentive reading? The first statement immediately. Delhi government announced a draft motor vehicle aggregator scheme 2023. Draft. Delhi government has passed a law. Then you can say at present it is valid because there is no dispute arising. Okay. However, you need to consider only the constitutional provisions, that is 69th amendment, which brought this 239 AA, which declared Union Territory of Delhi to be administered by Lieutenant Governor, who should work under aid and advice of the ministers only. And this Lieutenant Governor was, according to Article 239 AA, borne by the aid and advice of the Council of Ministers of National Capital Territory of Delhi, in relation to the matters within the legislative scope of it, and coming under all services coming under entry 41 of state list. But entry 41 under state list, there are certain exemptions only to Delhi government. What are those exemptions? With respect to land order, police and land. Except these three areas, remaining all services under entry 41 given to the state list can be executed by Delhi government, and it must be approved and followed by Lieutenant Governor of the Delhi. Next, memorandum of agreement was signed. This is with respect to ICMR, Ayush Ministry, signs an agreement on health research in integrated medicine. Health research in integrated medicine. What does it mean? A memorandum of agreement was signed between Indian Council of Medical Research and the Ministry of Ayush. What is this memorandum of agreement? I will tell you after 5 minutes, 10 minutes of break. Okay? Oh, it is already 7:20. So, we have started exactly 2 hours ago. So, shall I continue or I will continue tomorrow? Okay? Take care. Bye.